Thank you for tuning in to the Beyond Hourly podcast, hosted by Bentham IMF. As one of the world's most experienced commercial litigation funders, Bentham has invested nearly 2 decades into providing litigation finance and investment capital to plaintiffs and law firms. We offer law firms and their clients a risk-sharing partnership and a proven record of success as a leading global litigation funder. Episodes of this podcast can be found on our website, www.benthamimf.com, and on iTunes, Stitcher, and SoundCloud. I'm your host today, Sarah Tsou. Prior to joining Bentham's New York office as an investment manager and legal counsel, I spent over 12 years at Kirkland & Ellis LLP litigating intellectual property cases. At Bentham, I assess investment opportunities in the IP space and beyond, and act as a strategic resource for the parties we fund throughout the funding relationship. We have a very exciting guest here today, Steven Cherny. Steve is a partner at Quinn Emanuel in its Boston and New York offices. Steve has nearly 3 decades of high-profile patent litigation under his belt and has won some of the most important patent cases in the last decade. Steve also serves as a lecturer at the University of Chicago Law School and is a former member of the District of Delaware IP Advisory Subcommittee. I'm also proud to say that I had the privilege of working closely with Steve for a number of years while we were both at Kirkland. Steve, Chambers and Partners has described you as brilliant and very good in front of juries and very good with judges. I have no doubt you will also be very good on our podcast today.
I hope so.
Thanks so much for joining us, and welcome to the Beyond Hourly podcast.
Thanks, Sarah. Happy to be here.
So just for starters, can you tell us a little bit about your practice?
Well, I think you captured it with the 3 decades, which means I've been doing this for a while, and I guess means I'm kind of old. But basically, I'm a patent litigator or a patent trial lawyer. I know sometimes people say IP, but to be fair, I've done a lot more patent litigation and some trade secret in various courts than any other type of IP. So I think you can call me a patent trial lawyer and leave it at that.
Great. Well, you hold the record for collecting the most money from a single patent infringement judgment ever, more than $2 billion.
That's correct.
And I'm referring to the hard-fought battle between your client, Bard, and its competitor, W.L. Gore, on patents on artificial blood vessels. In 2015, which was a full 12 years after this lawsuit began, the National Law Review referred to the case as the apparently never-ending story. Can you tell us a little bit about the case and tell us, has this story finally come to an end?
Well, I'll answer the second question first, which is I'm pretty sure it's come to an end. It was a never-ending story that started probably around 1974. First as a fight between W.L. Gore and an inventor, a doctor named David Goldfarb, who shortly after 1974 ended up in a business agreement, licensing agreement with my client, C.R. Bard. They spent a lot of years, decades, fighting over who would control this very fundamental patent on this very important pioneering medical technology of artificial vascular grafts. And so after fighting over who would own the patent for 28 years, Bard and Dr. Goldfarb ended up with the rights. It then transitioned to litigation, which was Bard offered Gore a license under this Goldfarb patent. They couldn't come to an agreement, and then litigation ensued in the District of Arizona. And that's where I came in, because that's what I do. I'm a litigator. I was a fair bit younger when it all started back in 2003. And it culminated in a 2-month trial in the District of Arizona in front of Judge Murguia, who's now on the Ninth Circuit. We won a big judgment, willful infringement, attorney's fees, and also a very substantial ongoing royalty going forward. And when you put it all together, it's gone over $2 billion for Bard, and now the company that bought Bard, Becton Dickinson. But that wasn't the end of it. There also was a second trial where Gore sued Bard in the District of Delaware on the same technology. And we tried that case 2 years ago and won for Bard again. So after 2 losses, and I think the fact that Bard is now part of Becton Dickinson, I think Gore probably has moved on. Maybe. I mean, who knows? You can never tell. People
Never say never.
Never say never. But I think that the saga is probably over after, I guess, now 35 years.
Well, and we see lots of big patents.
45 years.
45 years.
Yeah.
45 years. So we see lots of big patent damages, verdicts, and awards. But in this case, you actually collected the judgment, right?
Yes.
And is that unusual in patent cases?
It is unusual. I mean, first of all, one can see it's unusual just by looking at the amounts of money that have actually been collected. There's been a number of large judgments over the years. I remember there was the Alcatel-Lucent Microsoft judgment over $1 billion. There was the Carnegie Mellon Marvell case. There's been a number of other ones. And, it certainly is notable and worthy of respect that people have gotten these large judgments in front of juries. But the Federal Circuit has been somewhat vigilant about really looking at those cases. And so there haven't really been any other ones that have over $1 billion that have stuck.
Well, what are the biggest hurdles that are faced today by claimants hoping to win big patent awards?
Well, probably the largest hurdle is the fact that the law hasn't really changed because it's based on old Supreme Court law, but the Federal Circuit has reinvigorated that law on what we call apportionment. And so for many years, you had people arguing for large awards and being successful, basically an argument that, whatever the patent was involved or invention in that case was worth some large measure of the whole product at issue. And the Federal Circuit has really pushed back on that and reinvigorated the doctrine of apportionment, which means that I have, for example, a Wi-Fi chip with 3,000 patents estimated just on this little chip. The Federal Circuit has forced people to value at trial, and the district courts have followed along to value any specific technology in the context of having thousands involved in a particular product. So I think that's probably been the largest. I mean, there's other issues, for example, the rise of IPRs, maybe some of the substantive patent law like Section 101 developing the way it has. But from my perspective, probably the largest obstacle to getting large patent judgment awards now is apportionment.
And how has apportionment come up in the cases you've tried?
So it comes up in most cases because it's necessary, the courts require it, but it actually has come up in terms of a bit of a contrast. So when I'm doing medical device cases, of which I do a lot, like the Bard Gore case, it's a little bit less present because the inventions tend to be less compound. And so you have a stent, you might have some number of patents involved relating to a stent, but there's only so many. It tends to be a structure, a device, maybe a method.
Not so many moving pieces.
Correct. Where it does tend to come up is high tech. And one case that I did where it came up in a big way was Cisco versus Innovadio, where I led a bench trial that was on valuing 19 patents that were being asserted against Cisco, and in fact, the whole industry of people that use Wi-Fi, and that was in Chicago. And we had a bench trial, and a big part of it was valuing these patents that Innovadio had purchased from Broadcom. And, Judge Holderman there in his decision, which is quite long, quite detailed, both well known for the way it deals with standard essential patents, but also for dealing with apportionment, essentially went through the fact that on a single Wi-Fi chip, which was the technology issue there, the estimates were that there were 3,000 different patents approximately involved in a Wi-Fi chip. And you took a look at it, and you start with the premise that a Wi-Fi chip costs $1 or $2, in the marketplace, and that leaves about 40 cents of profit. Again, I'm just approximating. And the judge took a hard look and said, okay, well, we've got to divide up that 40 cents between the, all these various and sundry innovations and contributions. And so it certainly was a big deal in Innovadio. And ultimately, in that case, the judge valued those 19 patents at 9.5 cents per chip, which Cisco viewed as a great victory because there'd be one or two chips in each of their access points. And so Innovadio had been asking for $200 licenses of $200 per access point, and they ended up getting like 9 cents or 20 cents per access point. So their apportionment was a big deal.
Well, and you mentioned some other sort of changes in the patent law landscape, and I know you've led a number of cases where new law was made. What, in your view, are the key changes in the patent law over the past several years?
Well, obviously, we have a whole new statute with the AIA, and people are starting to get used to that. I just had my very first trial on a post-AIA patent, and it was kind of interesting having to relearn all the things I had known for 20-something years. So
I feel kind of lucky getting out of practice before that happened.
Yeah, no, it was very odd. I mean, to all of a sudden not be able to talk about 102G, and I'm sure people who are listening are not really all that interested in hearing about all the sections of the patent statute, but there are all these things, these buzzwords and areas of invalidity, for example, that we all just kind of knew, and now it's collapsed down to only a small number, and we're really much more focused on first to file. So I think that's probably going to is the biggest and will be the biggest change for a while as we move towards more of a first to file system, where we're spending less time worrying about who conceived and reduced to practice an invention first and who filed it, and also looking at the impact of provisional applications. So I did this trial this summer in Boston and on 3D printing, and this was a big difference. So that was kind of odd having to relearn the patent law a little bit. There's other areas, obviously, people have been cognizant of how the impact of IPRs, patent litigation, Section 101 keeps going up and down in terms of, and it's even though the Supreme Court has addressed it a couple of times, I think, and as you noted, I teach at the University of Chicago. We talk sometimes with our students about there are some areas of the law where you're looking at a statute and they're interpreting like inducement.
Right.
But for example, with Section 101, it doesn't actually say anything. And so what happens is that the courts keep vacillating between, to left to right in terms of what is or is not patentable. And I think they're having a hard time. It probably is a worthwhile thing for Congress to get involved in at some point. But until that time, 101 is a moving target. So those are probably some of the bigger, and of course, apportionment, as I said earlier. These are all some of the bigger changes that affect patent litigation.
Seems like pretty uncertain times when it comes to filing a patent case and seeing it all the way through.
I think it's always uncertain times. I think it's just probably as of late, it's probably a little bit, the winds are a little bit against the plaintiff a little bit. Not entirely, but I think what you're seeing is a reaction. Venue being another big change in the law, obviously, that has changed the dynamic in terms of cases getting to Eastern District of Texas that may not, that now probably won't go there anymore. And so I think what we had was a generation or two that was pretty pro-plaintiff in terms of the law, and that caused a bit of feedback from the Federal Circuit. And so I think we're now on that swing in terms of response to, the non-practicing entities that developed over the last couple of decades, starting with Mr. Lemelson probably. And, I think we're on the side now of reaction, but I think we're seeing it kind of go back the other way a little bit. So there's always some uncertainty. It's just a matter of, like anything else, like the stock market or anything else, it's just getting a sense of where things are at this time.
So when you're advising your clients on claims they're considering bringing and the value of those claims, what are the key considerations you look for?
Well, first consideration is always the story, because, ultimately most of these things go to a jury. And, if you have a good story, jurors do the best they can, and they are very good at a number of areas, but they also tend to focus, somewhat like as most human beings do on the story. They're there for a couple of weeks or longer in a court. And if you have a good story that makes them feel that somebody has accomplished something, solved the problem, done something they care about, they're much more likely to value it than if it's something that, it seems to be very incremental, or if, for example, you don't really have a connection to the invention, meaning that, you purchased it from someone who purchased it, from someone else who purchased it, it doesn't tell as good a story. So ultimately, to me, as a trial lawyer, the story is the most important. Then you start looking at the technology as well, because, with a good story, medium technology can be worth a lot, and with a bad story, great technology kind of, isn't worth that much, because, again, the jurors have to connect with it. And you think about whether you can teach the jurors about it, whether it's something they'll be interested in. Obviously, when you're talking about an artificial blood vessel, they kind of feel it.
Sure.
They feel it themselves. Like, when you're talking about all the problems it solves, perhaps a little bit more connected way than if you're talking about something that saves power in their iPhone. Although, I have to tell you, a lot of times where my phone is running out of power, I feel that too.
Yeah, I've seen that.
But yeah, it's the story is most important. And then the technology and the issues that we discussed earlier, for example. Is this something where you're going to have to face a lot of headwinds relating to apportionment, because it's, one of thousands of inventions that people are arguing are included in a device? I'm not saying one way or other which way it should go. It's just you just know the arguments that people are going to make. And so
Right.
you have to be prepared for IPRs. I mean, you have to be aware of how much time and money is going to go into getting past that. And that has gotten less now that the patent office is swinging back a little bit from what they used to call the death squad. So those are the most important things. But again, to me, always a story is the most important. And also having witnesses that, the same exact patent on the same exact invention is a big difference if you've got an inventor who can get up there and tell a story versus just an expert, or, an expert who comes up and tells a slightly drier rendition of what happened.
Now, you mentioned non-practicing entities, and we've all seen in the patent litigation world cases brought by companies that don't practice the patent. First of all, do you think it's required to practice the patent in order to get a meaningful outcome?
No, I don't think it's required, obviously. Certainly not legally. It's not required. And for each individual case, I think the judge and jury is charged with valuing it. So even if someone doesn't practice the patent, a perfect example is a university. Universities often aren't practicing, but they are important generators of ideas and technology. So in that specific example, and maybe with a specific university, I could see them getting a very substantial outcome. And in fact, that's what happened with Carnegie Mellon and Marvell.
Right.
So it's not surprising. On the other hand, again, it comes down to the story. That's a different story than somebody who's set of patents out of bankruptcy. Although you can get a decent outcome there, you just have to find a way to kind of get the jury to understand why that those patents and those inventions are of great value to the defendant and why it is essentially they shouldn't be allowed. But it's all fact specific, but there's no reason why being a non-practicing entity means you can't get a decent judgment. It's obviously something that you have to work with. It's certainly not as compelling as, hearing a story from a company that's actually making something and who can talk about impact on their business of infringement.
It seems like it's so critical to have a good storyteller representing you in these cases. And in my new position, it struck me how important choice of counsel can be when it comes to evaluating a case's chances of success. What should litigants be thinking about when they're deciding who should represent them in these important cases?
I think exactly what you just said. And again, I would say this even after I get out of this business. So this is not a matter of advertising. I really do. When I teach my students, I teach patent litigation at Chicago. In fact, I was just there yesterday teaching. I mean, it really is about finding a way to connect with the jury. And so it's not about understanding the technology because the jury's not going to understand the technology. It's about teaching the technology. So I always say, if you get someone who's like Neil deGrasse Tyson or, the types of people who can take quantum physics and boil it down in 45 minutes so that the jury walks away feeling like they understand and learn something. So the trial I did this summer on 3D printing, you could tell the jury really appreciated learning something about 3D printing, how it works. And also the story of, in that case, my client, Greg Mark, who was a 37-year-old who had started a company at 31, and that company is now about to go over $1 billion in valuation. So it really always comes back to the story, whether it's the technology, the economics, whatever. And so you can find plenty of people who can understand technology or who can talk to you about biotech or whatever. If you're talking about winning a trial, you want someone who can connect with the jurors, tell them a story at a level they can understand and where they want you to win. I mean, I don't know if that comes through, but that's always been my perspective is that you're talking to 6 to 12 people who are probably a little bit bored, trying to do the best they can. And if they walk away saying, something, I understand a little bit more about 3D printing, for example, or an artificial blood vessel, why this is important, they're much more likely to go your way.
It's always been so interesting to me that such technological cases and such potential big damages awards can be decided by a group of lay people. But I've also heard it said that the jury generally gets it right. Would you agree with that?
Yeah, I think the jury gets it right often. Obviously, we have judges to review things, and I think our system works pretty well. I mean, it's hard to know oftentimes what it means to get it right. I mean, these don't tend to be digital decisions, but I think that they do have a nice sense of balancing where I think they can get a sense from listening to the facts, what's important or what's incremental. I think that they have a decent measure of witnesses and getting a sense of who's telling the truth and who's not. And at least from my perspective, one of the things they do, and judges do a great job and they do bench trials as well, but the jury is a little less jaded. I mean, judges have spent a lifetime listening to lawyers, and after all, and they also carry with them the baggage, even if they don't want to, of the last 100 cases. So I think it's probably a little hard for them not to kind of keep out of their mind that how this reminds them of some prior case or set of facts, which are really not relevant.
Sure.
The jury tends to have the benefit of getting people from multiple walks of life and their experiences, and the fact that they're coming at it fresh. So do they always get it right? Probably not, but that's why we have judges and the Board of Appeals to try to work on it, but they do a pretty good job.
Steve, I want to thank you again for appearing on Bentham's Beyond Hourly podcast and sharing your perspective. There's still so much to discuss. We're going to break here, but we invite our listeners to tune in to our next episode for the rest of our interview with Steve. As I mentioned at the outset, episodes of the Beyond Hourly podcast can be found on our website, www.benthamimf.com, and on iTunes, Stitcher, and SoundCloud. We'll be back soon with another episode focused on advancements in legal services that drive economic value for law firms and the clients they serve. Until then, I'd like to thank our audience for listening in and invite you to follow up with me, Sarah Tsou, at stsou@benthamimf.com for any feedback, ideas, or insights you have on topics we should cover on the podcast. Thank you and be well.